One of the biggest problems that we're having when we look at CPS cases and different things of that nature is that there are laws being used and there's nobody to give parents information on what we are to do. So here I'm bringing you real facts. I'm bringing you the United States House of Representatives website so you can look and see what the real truth is. Now, I'm going to let them speak from their mouth as a source of authority. You got to check this out. Now, what I want you to do is look at the red writing where I say look and I try to make a down arrow. Now, what I want you to see is that it tells us that a positive law title of the code is itself a federal statute. A non-positive law title of the code is an editorial compilation of federal statutes. This means that the positive law is actually a law that has been enacted by Congress, and that a non-positive law is one that has not been enacted by Congress, but it is an editorial compilation, meaning that someone can actually change things. Now, this is very important because when we look below, it's going to show us that Title 10, for instance, is enacted by Congress, but Title 42, by contrast, is not.
Now, to see the significance of this, look in the middle of the picture that I have up now. It says the distinction is legally significant. Non-positive law titles are prima facie evidence of the law, but positive law titles are evidence of the law. So it is the real evidence. It's not evidence on its face that could be proved as wrong. It is the actual law. And this is very important if we're going to be fighting for our freedoms, that we know if we're fighting using something that is real, that exists, or we're fighting using something that may be rebutted, or if we're even being brought to court on trickery. Now, if we look in the middle section of the document we're looking at, it says the distinction is legally significant. Non-positive law titles are prima facie evidence of the law, but positive law titles constitute legal evidence of the law in all federal and state courts. Let's go and look at this. Now, in Title 1, Chapter 3, I think it's Section 204, Codes and Supplements as Evidence of the Laws of the United States and District of Columbia. We're going to go to let's look at the first part. In all courts, tribunals, and public offices of the United States, at home or abroad, the District of Columbia, and each state, territory, or insular possession of the United States, look at A, United States Code. The matter set forth in edition of the Code of Laws of the United States, current at any time, shall, together with then current supplement, if any, establish prima facie the laws of the United States. That means on the face. It may be rebutted. General and permanent in their nature, in force on the day on the preceding the commencement of the session following the last session of legislation which is concluded, provided, however, that whenever the titles of such code shall have been enacted into positive law, the text thereof shall be legal evidence of the laws therein contained. In all the courts of the United States, the several states, and the territories and insular possessions of the United States. So what they're clearly telling us here is that, look, when you have the prima facie evidence of the codes, you can bring a case to court, and if the other side does not rebut or argue and say that this is not the real law, then what's going to happen is that the court is just going to stand on the prima facie evidence. So attorneys are smart enough to know that all they need to do is bring the prima facie evidence of the law, which might not be the real law, which might be changed, and they can take things from people, take children from people, and as long as the mothers and fathers do not know that they can bring the real evidence of the law, the public laws, the actual laws that are positive and enacted by Congress, the mothers and fathers can lose. All right, so back to the original document we were looking at. A non-positive law title of the code is prima facie evidence of the statute it contains. That means that it's not the actual law, it's just on the face law, okay? It could or could not be what is actually said. It can be rebutted, guys, by showing that the wording in the underlying statute is different. That means that there's a possibility that the underlying statute could be changed. A positive law title constitutes legal evidence of the law. It is considered to be more authoritative in all federal and state courts. Why is no attorney telling us that? Now, here we have what's called the Black's Law Dictionary, 5th edition. We're looking at the word common law. Now, a lot of people don't use this term these days, but there's a reason they don't use it. The attorneys won't tell us about the laws and which ones we're looking at because of this definition here, which all courts in the states, the superior courts, the appeals courts, and the Supreme Court should be moving by the common law. Notice what common law is. It says, as distinguished from law created by the enactment of legislatures, the common law comprises the body of principles and rules of action relating to the government and security of persons and property, which derive their authority solely from usages and customs of immemorial antiquity. Now, why is this important? The reason this is important is because the people created the courts. The people created the legislature, and we created what's called the common law in order to bind them so that they could not affect our rights. They could not make laws to deprive us of our property, deprive us of our liberty or our life. Notice that the common law is outside of enactments of the legislature. So when you look in Article 7 of the Bill of Rights in the United States Constitution, you're going to find that any case over $20 that we have a right to a trial by jury, and that no court of the United States can second guess the trial by jury under the rules of the common law. So the thing is that when courts and legal entities want to take stuff from us, they try to misapply United States codes to the people, and they try to curtail or bypass the law, which is the common law, which is not made by the legislature, but is made by the people. You could also see it in the Declaration of Rights or Bills of Rights in your states. You'll find that it will tell you that your liberty cannot be taken without due process of law. Nobody can just run in your house or affect your privacy or invade your home, okay? So attorneys are purposely doing this to keep us from understanding that there's a difference between the common law, which is not made by legislature, but it is made by the people, and it grants authority to the government officials to be able to protect our property and our rights. But the states have tried to hide it so that they can take our rights and take our property by using a separate system that only applies to them. We are protected from it by our Bills of Rights and Declarations of Rights. Now, to further prove it, let's look where it says after immemorial antiquity, or from the judgment and decrees of the courts recognizing, affirming, and enforcing such usages and customs, and in this sense, particularly the ancient unwritten law of England. See, unwritten, God put the law on our hearts. The common law is all the statutory and case law background of England, not really, but we'll continue, and the American colonies before the American Revolution. Now, why is this important? Before the American Revolution, there was no Title 42. Your children belong to you. They were given to you from God, and you couldn't just take them. Such law consists of those principles, usages, and rules of action applicable to government and security of persons and property which do not rest their authority upon any express and positive declaration of the will of the legislature. Now, people are trying to get you to believe that the legislature is in control and has power over your rights. This is not the truth. The legislature does not have the power to take over your rights just by their will, and they can't make local or special rules or special laws to take over your rights. Now, many people or many attorneys will try to keep us from focusing on the fact that we are the highest when it comes to the law. What we declare in our Bills of Rights and our Declarations of Rights and even other state declarations of rights have more power than what it is that the state has. On top of that, if you look at what the Bible says about God putting the law on your heart, this is where the common law came from. It has to do with reason, what makes sense. That's why they have to give you a jury of your peers, and the jury has to say, look, does it make sense that they're trying to put this man in jail when a child was being raped on grass and the man came to save the child from being raped on the grass, and he stepped on the grass in order to fight the man and stop the man from raping the child? Should we put the man in jail for that, or did he do what was righteous and just? This is what we have to realize, that we cannot play in these legal statutes when the common law is much higher.
Okay, guys, now that we know that there's a difference between the common law and the statutory law was created in order for politicians, the legislature, to be able to make enactments, to be able to determine how they are going to protect our rights and our property, right? Now, let me help you understand this. So the Constitution is a trust indenture. It is a limiting document. It grants authority. And then the Declarations of Rights or Bills of Rights says, and you can't touch this right that we have. You can't touch this property. You can't do this or that to us. So it is a trust indenture where you're granting authority for what someone can do, while at the same time limiting their ability to infringe on the common law or the law that we declared, the Bills of Rights, the Declaration of Rights. You can't invade my privacy. You can't take my liberty, life, or property without due process of law. You must have an oath and affirmation with an affidavit sworn under the penalty of perjury if you want to try to make a warrant to come touch me or any of my belongings or come into my property, right? So understanding this is why there's such a battle right now. Attorneys are trying to have as many cases as they possibly can to make money. The people are trying to exercise their freedoms, but they don't know how. So when we read the difference between a positive law and a non-positive law, think about this. If you have positive law, that is the legal evidence of the law, right? It's not the lawful evidence of the law. It's the legal evidence of the law, because the legislature does the legal things. The people created the lawful things when we created our lawful form of government with the Constitution, created all the seats, gave everybody the authority that they could have, and limited them right there. That was us creating lawful authority, right? We're standing on our lawful authority to create these entities called the state or even the United States of America. Now, when it comes to the legal aspect, the statutes and codes are created for those who we granted authority to be able to make decisions on how much toilet paper they're going to have inside of their court buildings. They can make decisions on how to prosecute one of their people if they do wrong against us, if they go beyond their authority, if they lie on the job, if they do something wrong. They can make statutes to control administratively what they're going to do. Now, that did not give them the authority to just run roughshod over the people and apply their statutes to everybody, but they use some trickery to try to do it. They don't give you full disclosure. They say if you signed up for the Selective Service, if you use a zip code, certain things, they try to use trickery to make it so that they can extend their jurisdiction over you. Remember, the District of Columbia is 10 square miles, and that is where the United States is seated. Now, when you see where it talks about insular possessions, territories, and their stockyards and different things, they're talking about places that they purchased or own, right? Or contracted for. Now, that has nothing to do with the people in the states. The people in the states are protected by the state constitutions, the Bills of Rights, and the Declarations of Rights, and they never teach you that. The reason they never teach you that is because it's based on the common law, and if we use the common law, they could not take our property, take our children, they couldn't write statutes and leave them ambiguous or mess the words up or whatever so they could do things that they're not supposed to do. And think about this. If you have what's called the positive law, which is exactly what you wrote and what you said, why would you ever have another version called a non-positive law that has editorial compilation or be different? Some people will say, oh, well, that's just a mistake. Why do we need it? It's kind of like saying if I got the Bible with the exact word that God said, why would I need commentary? I can read what God said. I can go over it. I can read it in context. I could go over it again until I understand. I can match it with other verses to see what God is saying. But if I use a commentary, anybody can editorially compile a whole bunch of verses from the Bible. And if you change them, it's no longer the verses of the Bible. It's no longer pure. So we have to understand this same thing with law. Now, people want to find out how to win. Well, when you have a Bible argument and somebody tries to give you commentary, you rebut it with the actual text of the Bible. In the same way with the law, when somebody tries to give you an editorial compilation where they just took a whole bunch of pieces, edited, tried to say what they think it means, I'll just take the real word of the law and blow you back with it. This is exactly what we learned on the United States House of Representatives website, where we see where it says that you can rebut what is being said with the prima facie evidence called the Title 42 or some of these different unpassed laws or editorial compilations of a whole bunch of laws that have been changed. See, editorial compilation means that they have went through and tried to make it smoother, sound different from what they say. But a lot of times when people say that in science, or a lot of people say that in scholarly study, you'll find that when they do that, they're trying to change the words many times so that they can make it mean something closer to their belief system. So when somebody wants to subvert the Constitution or the law, it is not the best to attack the Constitution directly. It's the easiest to make a whole bunch of statutes and codes, say that you're compiling them and putting them together so they're easier to understand, and then you change them. That's how it's done. So I want you guys to think about this and see this. And then I'm going to take you to adoption. So you can understand that if your kids have been adopted by a statutory process, then it was not done by the common law, which means it was not done by the law of the land, which means that they don't have the final say. Which means the people can now have a trial by jury. The people can actually come back and rebut the presumptions that show that they never had jurisdiction over you in the first place. And you can bring all the cases back and flip them all over. All right. Now I'm going to show you adoption, Black's Law Dictionary, 5th edition. So to prove my point even further, we're going to look at adoption, which is in Black's Law 5th edition as well, legal process pursuant to state statute in which a child's legal rights and duties towards his natural parents are terminated. Similar rights and duties towards his adoptive parents are substituted. To take into one's family the child of another and give him or her the rights, privileges, and duties of a child and heir. The procedure is entirely statutory and has no historical basis in the common law. Okay? So what we need to understand, guys, is that this whole idea of adopting people's children out against their will is found nowhere in the common law. The common law is the law of the land. The common law is the law that protects mothers and fathers from encroachments on their rights. It protects the people from having government officials and employees running in and stealing things from you against your wishes and against your rights. So this whole idea of using Title 42 without the constitutional protections as a non-positive law to say that there's authority to take children and adopt them out and do all these things. Where in Title 42 does it say that you are allowed to take somebody's child from them in a for-profit program under Title 4E? It is not right. It does not exist. The general law, the Social Security Act, the law that was actually passed by Congress in the original legislation, 1935, actually says that you can't take children from their parents against their objection, period. Okay? You can't do it. Okay, so to clearly show that the laws are being broken and people know, let's check out the Guardian Ad Litem handbook from Pima County, Arizona. It says, we say that the court is not about parental fault. This is in the last paragraph. That is certainly true under the law. However, the dependency process is a terrifically human. While the law may say otherwise, in actual practice, fault, blame, shame, attitude, and a host of other technically irrelevant considerations play a huge role in determining what will or will not happen to a child in the court process. None of the participants, including the judges, case managers, therapists, and lawyers, are immune from visceral reactions to parental behavior. That will in no doubt include you. Now, what just happened here? We just literally seen where we can view the guardian ad litems being trained in their guidance documents, telling them what to do and how to work, that even though the law says otherwise, they're going to use things that are outside of the law to make a determination on where a kid goes. That means that this whole system is not about the law, and this is evidence of things being the way that I say. The guardian ad litems are being trained to not look at the law. Now, in a real court of law, they would be looking for who did wrong, who broke the law, who broke a contract. Look what it says in the middle paragraph. In theory, the juvenile court is not in the business of finding fault, assessing blame, or meting out punishment. See, they're not here to tell if you did something wrong. They don't care about necessarily arresting you or putting you in jail for doing wrong. Their whole job is to take kids from one home and put them in another for money. Let's see. Rather, the juvenile court is interested in protecting the child from immediate harm and in providing services, that's what they get paid for, necessary to help preserve the family. They're not really trying to preserve the family if they make more money selling the kids. If efforts to help the family, to make the family function do not succeed, then the juvenile court is empowered to find an alternative, permanent, and safe home for the child. Now, here's the problem. What if there was never anything wrong in the first place and the CPS worker just took them because they wanted to? What if the CPS worker took them because they were upset that the parent didn't like them or the parent had an attitude with them? That would totally not break the law if a parent was upset with them, but that doesn't mean that they won't use blame, shame, attitudes, and a host of other technically irrelevant things in order to take a child. Guys, I am showing you that this system is purposely breaking the law. Okay, so I have just hit you with a whole bunch of evidence. Now, I'm going to leave you with this last bit from even the statute of Arizona showing you the common law. This is going to explain to you that the common law is for the people. It deals with the Constitution, which the people made. It is all about the people's business, and the government officials are not over that, right? So it comports with the Constitution of the United States of America. It goes along with the Constitution of Arizona because the Constitution is where we, the people, lay down the law and handle our business, and it is what it is. All right. I'm going to show you this evidence, and we're going to end this up so you guys can see that someone is not telling us the truth. Okay, now here's where we have it in the statutes of Arizona, adoption of common law exceptions. The common law only so far as it is consistent with and adapted to the natural and physical conditions of this state and the necessities of the people thereof. See, the common law is the courts of the people and not repugnant to or consistent with the Constitution of the United States or the Constitution or the laws of this state. Well, the Constitution of this state was created by the people. So I don't think the common law is going to go against what the people want or establish customs of the people of this state. Is adopted and shall be the rule of decision in all courts of this state. Now, did this just tell us that the common law should be the rule of decisions in all courts of this state? Then understand, guys, that when you talk to attorneys and they say the common law don't exist, the common law, that was old stuff, we never heard of it before, we don't deal with that common law stuff, right? No, the common law shall be the rule of decision in all courts of this state. They even hide this in the freaking statutes in Arizona. Now, if you don't understand that you're being tricked and that the common law is real and we need to use it, then I don't know what else to tell you. But this is real proof. This is stuff that you can stand on. Are you going to be wise or are you going to be deceived? It is your choice.